Part of the law Congress passed to regulate how agencies create rules and regulations is known as the Administrative Procedures Act, or APA. Section 706 of the APA requires courts to hold unlawful and set aside agency actions, findings, and conclusions found to be arbitrary, capricious, and abuse of discretion or otherwise not in accordance with the law. If a court finds that an agency acts in an arbitrary or capricious way or beyond their legal authority, it must hold those actions as unlawful, therefore deciding for the plaintiff who sued. The repeal rule falls short of these standards. We discussed the department's inadequate consideration of important aspects of the energy conservation program. Then we discussed the repeal rule's reliance on purported legal error. Things aren't looking so good for the Department of Energy at this point. In 2022, DOE was required to reasonably consider the relevant issues and reasonably explain its decision in the repeal rule. It failed to do so. Specifically, it is unclear that DOE has statutory authority to regulate water use in dishwashers and clothes washers. But even if DOE has water usage authority over the relevant appliances, the department failed to adequately consider the negative consequences of the repeal rule, including the substitution effects of energy and water wasting rewashing, pre-washing, and hand washing. And in all events, the 2022 DOE failed to adequately consider the impact of the energy conservation program on performance characteristics. Basically, the court found that DOE tripped over itself in two primary areas: their legal powers and the impact of the repeal rule. Let's look at these individually. In promulgating the repeal rule, DOE stated that its energy conservation program must promote water conservation and regulate water use. But it is unclear how or why DOE thinks it has any statutory authority to regulate water use in dishwashers and washing machines. First, there's the question of whether or not the Energy Policy and Conservation Act of 1975 delegates to the Department of Energy the authority to regulate water use for these appliances. The EPCA allows DOE to regulate energy use by some products and water use by others. The ECPA does not appear to contemplate overlap between the products subject to energy regulation and those subject to water regulation. Energy first. The EPCA defines energy use as the quantity of energy directly consumed by a consumer product at point of use, and defines energy as electricity or fossil fuels or other fuels. Dishwashers and laundry appliances obviously use energy as the EPCA defines that term. So it makes sense that the DOE can regulate the amount of energy used by those appliances. But the statute defines water use as the quantity of water flowing through a shower head, faucet, water closet, or urinal at point of use. And the four explicitly enumerated water products do not use energy as that term is defined by the EPCA. That explains why Congress said energy use or water use. So first, the court found that the Department of Energy did not have the statutory authority to regulate water use in these appliances under the EPCA. I'll talk a bit more about that later. Now, what about the second problem the court found? Even if DOE could consider dishwashers and clothes washers efficiency in both energy use and water use, the 2020 rules likely promote greater efficiency in both categories than the repeal rule. Assuming both energy conservation metrics are on the table, the states argue, and DOE does not appear to dispute that one important aspect of the problem is whether appliance regulations actually reduce energy and water consumption. Yet the administrative record contains ample evidence that DOE's efficiency standards likely do the opposite. They make Americans use more energy and more water for the simple reason that purportedly energy-efficient appliances do not work. So Americans who want clean dishes or clothes may use more energy and more water to pre-clean, re-clean, or hand wash their stuff before, after, or in lieu of using DOE-regulated appliances. Strike two for the Department of Energy. It appears not only has the DOE gone beyond its statutory power, but in the name of being energy efficient, their latest rules actually promote the use of more energy and water to do the same job.